Good morning, everyone. My name is Scott Sweatman. I'm a partner with the Vancouver office of Dentons. I'm in the Employment and Labor Employment Department. I head up the pension benefits and executive compensation practice, national practice. If you're wondering if you're on the right seminar, this is a seminar about workplace privacy, AI issues, biometrics, key updates for the haunted office. We need a Halloween theme today, of course. Things that keep you up at night. I don't know what keeps you up at night, but lots of things do for me. Just because the world's become a complicated place, and this is some of the topics that I think we need to address. I'm delighted to introduce my colleagues from across Canada. We're a national practice, as many of you know. Joined in this order in the speakers will be Maggie Sullivan. Maggie's an associate in our Ottawa office. Maggie advises employers, I should say, in all aspects of employment relationship, from terminations to human rights and accessibility. Roxana Yangi is a partner in our Calgary office who focuses on labor, employment, human rights, and privacy law. Joined, last but not least, is my colleague from our Vancouver office, Victoria Merritt, who is a senior associate. She provides practical, risk-based, risk-focused advice to help employers manage complex workplace issues. I work with Victoria quite a bit in our Vancouver office. You're well represented today. Today's session will shine a light on some of the hidden dangers that lurk in the modern workplaces, from violence and harassment to secret recordings and employee monitoring. It is a scary topic on an appropriate day. We'll explore workplace violence and the evolving duty to protect employees from that violence, secret recordings, and when they might cross the line into legal or disciplinary trouble. And finally, employee monitoring, what's permissible on the monitoring front and what could lead to compliance nightmares.
Hello, everyone. Thank you very much, Scott. Happy Friday, happy Halloween, and most importantly, happy World Series Game 6 day. I have my Blue Jays hat here, and I may or may not be dressing up as John Schneider for Halloween tonight. So I hope everyone is sending their positive thoughts to the Toronto Blue Jays. I know I am. So with my personal housekeeping taken care of, I'll move on to my presentation. And as Scott mentioned, I'm going to be talking to you today about workplace violence. I'm going to be talking about workplace violence generally, but I'll also address a perhaps less discussed issue, which is instances where violence may be committed by third parties, such as by the clients or customers of a company, or by an employee's spouse, intimate partner, or other family member. And these topics can be a bit heavy, and so please feel free to step away or take the time you need if you do need to do so. With that, I'll move right into it with the first slide, please. Okay, perfect. So the first question is, what is workplace violence? And even perhaps before we get into that, I'll note that the broad and overarching law here is that employers have a legal duty to protect their employees from occupational health and safety hazards. And workplace violence is an occupational health and safety hazard. So then, what is workplace violence? I've pulled the definitions from 4 of our provinces across Canada, and they're on the screen here, and these will be circulated to you after this event. And I won't bore you with reading these definitions out, but what we can pull from these definitions is that workplace violence is very broad. It can include actual physical violence, psychological violence, sexual violence, threats of violence. It can be physical force, gestures, actions, conduct, or words, whether orally or in writing, that can cause injury to an employee or that threaten to cause injury to an employee. So it is very broad. And with that understanding of what workplace violence is, what can and must employers do? We'll go to the next slide, please. So there's a number of things that employers need to do as it concerns workplace violence in their workplace. First, there are policy and program requirements. Employers must develop written workplace policies and programs that outline requirements and expectations as it concerns violence and conduct in the workplace. These policies should also address how incidents of violence can be reported, how they'll be investigated and addressed, what training requirements will be in place, et cetera, et cetera. Employers must also conduct risk assessments. Employers are expected to assess the risks of workplace violence that may arise from the nature of their workplace, the type of work employees are engaging in, the conditions of the work, and then take steps to mitigate against those risks. Employers must also make sure there's proper incident reporting mechanisms, and then make sure that they investigate all reported incidents of workplace violence. So all incidents and threats must be taken seriously with prompt investigations and appropriate corrective measures. And lastly, employers need to train and communicate with their employees. Workers should be trained on all policies, on the reporting mechanisms, on the emergency response protocols, and all of the systems in place that set out expectations and situations for how employees can respond in incidents of workplace violence. And I think that an important way to view these requirements is as an organic process. It's not linear and a mere checking of the boxes. These are boxes that do need to be checked. You need to make sure you have the policies and the training programs, but it should not then be an out of sight, out of mind situation. Instead, these matters should be revisited as often as needed and at least on an annual basis to ensure that they're still adequate and appropriate for the workplace, or to determine whether any updates are needed based on a new assessment of risk. So with that, let's discuss situations where employees may be subject to violence by third parties. And I'm going to start with violence committed by clients or customers. Now, this slide has a lot of text, so I'm sorry if that's jarring, and I'm not going to read it all out. I'm going to explain it nicely. Starting out, I think it's important to recognize that certain employees will be at a greater risk of violence by clients and customers, but due to the nature of their work in the industry that they work in. So for example, people who work in care homes with differently abled people, people who work with troubled youth or youth offenders, or perhaps people who work with people overcoming trauma or substance abuse issues, etc. These employees may be at a greater risk of violence by those individuals they serve simply due to the vulnerability of the communities they work with and the nature of that work. And this is relevant when we consider the scope of an employer's duty to keep employees safe from violence. And jumping to the chase, this can sound like a daunting task, particularly for these high-risk employment environments. But the good news is that, in my view, the workplace violence obligations are not so difficult that employers in these industries in particular cannot effectively run their business. So taking a step back, under occupational health and safety legislation, and I'm going to focus on Ontario's Occupational Health and Safety Act as I work in Ontario, but there's similar mechanisms across the provinces. But under the legislation, employees have the right to refuse unsafe work. And workers may refuse unsafe work for a number of reasons. One being if they have the reason to believe that they're likely to be endangered by workplace violence. However, this does not apply to all employees, and it won't apply to employees who are in certain professions if violence would be inherent in their work or if the refusal would endanger the life, health, or safety of another individual. And then turning then to the right, to the text in the purple bubble, those professions captured in the list there are the exception, where if violence would be inherent or a regular occurrence in the job, those employees cannot refuse work on the basis that it's unsafe because they may be subject to violence. So you can see there it includes the very obvious industries where there's inherent danger, such as the police service or the fire service, and also includes individuals who work in facilities where they may be servicing differently abled individuals, people with behavioral or emotional problems that can result in a higher risk of violence. And so if we connect all these dots, if you work in one of these facilities and the exposure to violence may be a regular condition of your work, you cannot refuse the work on the basis it's unsafe. And so as a result of that, and as noted, the workplace violence obligations are not so difficult that employers in these industries cannot effectively run their business. The key then, though, is that all employees, and perhaps employees particularly in these industries, need to have good training on how to handle dangerous situations. Also key is to do a very thorough and very careful workplace risk assessment, ideally with a broad involvement of your employees. After that, it comes down to implementing policies and procedures to protect employees to the best extent possible based on the risk identification. Perhaps this involves making sure there's locks on doors, making sure knives or other sorts of instruments are only in locked cabinets, only accessible by staff. Perhaps it may even be providing staff with padded clothing when they may be dealing with certain individuals. There's a number of safety measures that can be put in place depending on the risk assessment. Okay, and I'll move to the next slide, please. So the next topic then is domestic violence, and legislation in many of the provinces, including Ontario, Alberta, and Quebec, explicitly recognize domestic violence as a workplace safety issue. Under Ontario's Occupational Health and Safety Act, it states that employers who become aware of or who ought to reasonably be aware that domestic violence can expose a worker to injury in the workplace must take every precaution reasonable in the circumstances to protect that worker. Now, what is domestic violence? Domestic violence occurs when the violence is committed by a spouse, intimate partner, or other family member. It can include physical abuse, verbal and emotional abuse, financial control, and more. Statistics Canada reports that women are grossly overrepresented among those who experience domestic violence. That said, it's not exclusively a women's issue, but I do think that an employer's efforts to safeguard its workplace from domestic violence will not only be in furtherance of its occupational health and safety goals and obligations, but also in furtherance of the goal of ensuring gender equality in the workplace and women's empowerment in the workplace. So with that background, if an employee or third party alerts an employer that an employee may be dealing with intimate partner violence or domestic violence, the employer must ascertain the risks posed and take steps to reduce those risks. And even prior to an incident, there are obligations. So what does this look like in practice? Well, here we have a number of things on the slide here. And I've broken this out into general obligations or best practices, and then obligations and best practices when there is an incident. But similarly, it's organic and not mutually exclusive. In any event, I'll go through these. So employers should consult and communicate with employees regularly to garner ideas and suggestions for proper training programs and workplace policies. So you can consult with your women employees and all employees to understand what they would maybe want or need if they were to experience domestic violence. Employers should also put in place workplace support and safety measures, perhaps in situations of remote working, for example. So for example, employers can disseminate a safety code or a hand signal that individuals working remotely can use if they need to ask for help in a secretive manner. Employers can also regularly conduct domestic violence and security training, and perhaps particularly for company management. So managers can be taught non-judgmental listening skills or trauma-informed management training. And employers should then foster a workplace culture where employees feel safe to report. And I think that by doing all these things that I've already mentioned, that culture will more or less fall into place. By taking these steps and being vocal in this positive fashion, I would be hopeful that this would create an environment where employees will feel safe to seek help without fear. And the last thing on that first list there is to be attentive to the signs of domestic violence. So the physical and social signs that an employee may be the victim of intimate partner violence. So for example, is the employee experiencing unannounced or inappropriate visits or calls from a partner? Is the employee demonstrating a marked change in demeanor that could indicate that maybe a conversation is needed here? These are things employers should be aware of. And then in the event a report is made, there's more specific things that employers can and should do here. So there can be case-specific assistance measures and a personal safety plan. This may involve changing work locations, schedules, security arrangements, and the like. Relatedly, employers should work with employees to assess the risks that are present to them and to the workplace. And again, this can involve a difficult conversation, but employers do need to take the time to understand these risks so that they can adequately address them. And throughout this process, employers should be respectful of employee privacy. To the extent possible, these conversations should be kept in confidence and only disclosed to the extent necessary. And lastly, employers can provide support and resources. So perhaps resources can be displayed to all employees generally in the workplace, but specifically when a report is made, these resources should be made known to that employee, whether they're internal to the company, such as through benefits plans and programs, an employee assistance program, or whether they're local community resources. An employer should also make employees aware of the leaves which may be available to them. And there are domestic violence leaves in a number of the provinces, including Ontario. I'll go to the last slide then, which is just a broad thank you slide. But to close, workplace violence is a real occurrence and a real problem that employers need to be cognizant of. This is, of course, a legal issue, but it's also a human issue, one that impacts morale, retention, and organizational reputation. And so by understanding the legal framework and implementing these practical safeguards, employers can protect their people, limit legal exposure, and promote a culture of trust and safety. That's it for me then, and I will turn it over to my colleague, Roxana Jangi.
Thanks, Maggie. Good morning, everyone. Thank you for joining us today and happy Halloween. As noted, I will be diving into the topic that is becoming more and more common these days, employee recordings in the workplace. I will be focusing on topics such as whether employees can legally record conversations without consent, when this kind of behavior can amount to just cause for termination, and whether such recordings can be used as evidence in court proceedings before administrative tribunals, as well as in civil matters as well. And then I'll wrap up the presentation by discussing some practical steps employers can take to reduce risks around all of this. Prior to jumping in, I do want to highlight that the focus of my presentation today, at least, will be on employee recordings and not the other way around. So that is just an important distinction I wanted to flag, because employer recordings of employees and so forth and monitoring is a whole other topic. So now turning to the next slide, we'll jump into the first question of whether employees can legally record others in the workplace. So technically, yes, but there's a big caveat to all of this and how it comes into play in the employment context. But to start off with, under the Criminal Code of Canada and in Canada generally, we follow what is called the one-party consent rule. This means if you are part of a conversation, it is generally legal for you to record it, even if the other people participating in that conversation do not know you're recording them. What is not legal is recording a conversation that you're not a part of. So for example, if Angela records a conversation she's having with Brad directly, that's generally fine. But if she hides her phone and records a private conversation, Brad is having with someone else in another room, that would cross the line and is generally considered intercepting a private communication. Now, while these principles all come out of the criminal code and so forth, the courts, including in Canada, have adopted a similar line of reasoning in the employment law context. So employee recording their own meetings or performance discussions isn't necessarily breaking the law by simply doing so, but, and this is the real key, legality doesn't necessarily mean appropriateness. So even if taking a recording is legal, it can still be considered misconduct or a breach of trust. And in some cases, it can still amount to just cause for termination or discipline. And that's a separate question we'll get into momentarily. But a good way to think about all of this is to think about it like alcohol and cannabis. Both are legal, but it doesn't necessarily mean it's acceptable to bring a 6-pack of beer to a staff meeting or show up high to a safety-sensitive work environment. Employers in those contexts can set boundaries through appropriate policy and also discipline or even terminate inappropriate circumstances. So I'd say that's kind of the distinction that I would make, and the analogy I would make to kind of help understand all of that. So now turning to the next slide, and we'll jump into the topic of whether making a secret recording with an employer can amount to just cause. So the answer to this, like most things in employment law, is it depends. There's no automatic rule that recording coworkers or managers secretly equals to just cause, but in the right circumstances, it absolutely can. And we're going to look at 2 cases today that show both sides of the coin here. One where recordings were just justified cause and the other where it did not. But before I dive into the cases, It is important to remember the threshold for just cause is extremely high, and if the matter ever goes to trial, the ultimate onus is on the employer to prove cause. And the key test to establish just cause has been laid out in the Supreme Court of Canada case McKinley versus BC Tel, which established that the big question to be answered is whether the conduct in question, so in this case, taking secret recordings, is so serious that it destroyed the trust and confidence essential to the employment relationship. And this analysis has always been contextual, meaning the courts will look at the full picture and things such as the nature, the seriousness of the misconduct, position of the employee, length of service, intent, motive, importantly, employer policies, which I'll highlight quite a bit in the coming up, and the impact on the employer's business. And just because we're talking about secret recordings, for all you lawyers out there, we don't throw out this framework. We still have to apply it. And that's exactly what the courts did in the cases that we're about to look at and discuss. So the first decision that I want to chat about is Shaligan versus Mercer. And that's a decision that came out of BC. And the second one will be Rooney and GSL Chevrolet, which came out of Alberta. So in Shaligan, the BC case, the sole question before the BC Supreme Court was whether secret recordings made by an employee during their employment could amount to just cause. Essentially, what happened in that case was that there were several discussions between an employee and their management about their bonus entitlements. These discussions eventually became heated, and at one point, the employee threatened legal action, sending an email saying something to the effect of he was willing to resolve things internally without first proceeding to litigation. The employer understandably got concerned and really uncomfortable with the tone of the email and the threat of legal action. So they ultimately terminated this employee, but they did so without just cause. Afterwards, the employee filed a human rights complaint and a wrongful dismissal action. And it was during these proceedings that the employer discovered that the employee had secretly recorded a large number of recordings in the hundreds, and not just with HR, but with other coworkers and subordinates over roughly a 10-year period. And these recordings included everything from training sessions, bonus discussions, to unrelated personal conversations, even capturing some sensitive and intimate information that coworkers had shared. Now, the employee had not shared these recordings publicly or made any money from it. He claimed he started initially recording this because he was improving his English skills and later to document what he described as harassment and bullying. And in reviewing the evidence and the legal principles, the Supreme Court of Canada, the BC Supreme Court made it clear that while one-party consent may be legal in Canada, legality alone is not decisive. And the real question following the McKinley framework we talked about earlier is whether an employee's conduct taking secret recordings undermines the essential element of mutual trust in the employment relationship. And the court in this case said that it did. In coming to its conclusion, the court looked at the full context, and there were several critical factors that really came into play in leading the court kind of down the line that it went. The first one was that the court commented on was the volume and the duration of the recordings. The court in this case said this wasn't an isolated lapse in judgment, but it was a pattern of conduct that sustained over many years, involving numerous employees at all levels of the company. Second, the court noted that the content of some of the recordings went far beyond workplace matters and captured personal and sensitive discussions, which the court said was highly intrusive. And the court also pointed out that the plaintiff likely knew he was doing something that would make people uncomfortable and would be considered unethical, because he admitted during trial that he did not ask for consent because he knew his coworkers would object and would feel uncomfortable. And the court also noted that this was a senior level employee and should have recognized that his behavior was unethical and damaging trust. And what was really important in this case was that the employer had a policy on the issue, prohibiting such conduct. And the employee was aware of the policy and had signed off on the policy. So he also knew what he was doing was against the rules of the employer and was not permitted. So that was definitely quite an important reason that came into play. And two others that the court kind of pointed out that I think is important is that they also looked at the reasons behind taking the recordings. And the employee in this case said, it was primarily done to protect his interests, his legal interests. And the court said that this wasn't credible. And what the employee was essentially saying was that he was taking the recordings because he was being bullied and harassed. And the court here said there was no credible evidence that the employer had acted unlawfully or in a manner that would justify these measures. In fact, there was evidence to show that the employee was really treated really fairly all throughout. So the courts did not find that persuasive. And then finally, what the court said in this case was policy came into consideration because the courts warned that tolerating this type of conduct would encourage other employees to secretly record. And that was something that they didn't necessarily want to encourage because they were worried about the chilling effect that could have on the workplace moving forward. So particularly privacy rights and so forth. So on a combined basis, the court held that the recordings did fracture the employment relationship and justify just cause. So here you have a case, and what I would say this case really stands for overall is the proposition that even though making recordings may be considered legal, the act of secretly recording your coworkers, especially over a long time on numerous occasions with a clear policy in place that prohibits such conduct, can amount to just cause. And with that in mind, I'll turn to the second case now, Rooney and GSL. That's a case that came out of Alberta. And this case also looked at whether an employee's secret recordings amounted to cause. And here the facts and the context really, really matter. So this case involved an employee who claimed constructive dismissal. Here the employer had unilaterally reduced the employee's duties and income quite significantly, and even placed the employee on an unpaid leave. And after taking these actions, the employee really became concerned that he was being set up as the problem employee. So he decided to record a disciplinary meeting he had with his manager, not to entrap anyone, but really to protect himself and document how this manager was treating him in the workplace. And at trial, the employer counsel relied heavily on Shaligan, so the BC case, arguing that the same principles should apply. But the Ontario Court of King's Bench reached an opposite conclusion, and that distinction really came down to the context and the reasons behind why the employee took the recording, and importantly, the fact that the employer did not have a clear policy in place addressing the issue. The court in Rooney, so the Alberta case, began its analysis by agreeing that secret recordings can destroy the employment relationship and emphasized but what they did is, in this case, they emphasized that the employment relationship had already been fractured and strained because of the employer's conduct prior to the employee taking the recording. Here, the employer had already made unilateral changes to the employee's duties, compensation, and placed him on a leave, all actions which had eroded the trust. And the court said here that given this context and circumstances, it was reasonable for the employee to feel disempowered, and that this recording and that his taking the recordings were not an attempt to deceive or manipulate. It was really a defensive act and a way to protect himself where he felt vulnerable and cornered, especially given the power imbalance in the employment relationship. And another key distinction here, again, I alluded to it earlier, is that unlike Shaligan, there was no evidence of a clear policy prohibiting recordings. And so there was no signed acknowledgement that there's no policy, or the employee didn't sign an acknowledgement on the policy showing that such conduct was forbidden. And the court said that without clear rules, the employee could not have known that their conduct was prohibited. So in light of all of these circumstances, the court concluded that the employer did not have just cause to terminate the employee. So really, in looking at these two cases, I would say the judge in Rooney essentially drew a line between recordings that are taken for what I would say defensive purposes to protect an employee against perhaps the actions of an employer versus perhaps recordings taken to entrap or personal gain. And I would highlight really the importance of having a policy and how that came into play in the decision-making process for these justices. And before moving on to the next slide, one thing I will quickly touch on, I know this could also be a broader topic, but I want to add there is a bit of a different layer of risk when we are talking about recordings that are shared publicly, like on social media. In these circumstances, the courts tend to take a much harsher view because you're no longer dealing with perhaps like a private act, but also dealing with conduct that could damage an employer's reputation, breach confidentiality, and so forth. So when a recording is posted or distributed publicly, that can very well easily tip the scale towards just cause, even where a private recording may not. So I just wanted to quickly highlight that before getting into the next topic. So next we are going to look at the admissibility of secret recordings into evidence. And this is another issue that often comes up with secret recordings, is whether they're admissible in legal proceedings. And here, I think it's important to distinguish between labor arbitration cases and civil court cases. So in the unionized context, where arbitration rules are much more flexible, some arbitrators have excluded secretly obtained recordings, not because they lack relevance, but because of policy grounds. Their concerns being admitting such information could undermine trust in an employer in the workplace and create a chilling effect on cooperation and collaboration. So there are some cases, if you're ever dealing with this issue, where in the arbitration context, especially out in BC, and where they'll say, perhaps for policy reasons, we'll exclude this. But it's really important to note that this approach is not taken by the courts at the higher levels in the civil context, especially in Alberta. And the Rooney case discussed that I noted earlier is a really good example of this. So in that case, the employer first argued recording should be excluded for two reasons. Primarily, first, because it was unreliable because parts of the recordings were inaudible. And the second reason was based on policy grounds that admitting the recording could motivate such type of behavior and have a negative consequence in the workplace. So really what the arbitration cases, some of the arbitration cases highlighted. And the court rejected both arguments and stated the recordings were clear and had been authenticated. So the first line of argument was not accepted. And then also the court refused the policy argument, noting that the test for admissibility of evidence and the test for just cause are two different questions. So while all of these policy concerns are relevant to determining whether an employer has cause to terminate, they are, like we saw in Shaligan, the test for admitting evidence is a different test and takes into account different considerations. And in Rooney, the court really clarified that when you're looking at whether evidence should be admitted, the focus should be on relevance, and the key question there is whether the probative value of the evidence outweighs its prejudicial effect. And in simpler terms, that's just the courts, what the courts really say is that the courts will look at how helpful the recording is in proving a key issue and whether it could unfairly potentially mislead the judge or the jury. So if it's relevant, it doesn't have the impact of unduly negatively misleading, generally speaking, they will allow it. And so far, the trend that I'm seeing in Alberta and elsewhere has been towards inclusion. Courts are generally prepared to admit these recordings where they shed light on issues such as credibility, bad faith, just cause as well. So that's just a quick overview of how that will be treated. And then moving, I guess, on to the next slide. After hearing all this, I think the natural question that comes into play is what can employers do to mitigate to mitigate the risks around employee recordings. And I think the first biggest thing would be to adopt a clear policy that addresses recording specifically, or incorporate rules around this into other policies, such as your code of conduct, perhaps if you have confidentiality policies and so forth. But this is extremely important because it's come into play in both those decisions and is a consistent thing that the courts will look at. And these policies should really specifically set out that recording a workplace conversation without consent is prohibited unless it's consented to or required by law. The policy should also clearly outline the consequences of breaching the policy, so discipline up to and including termination for just cause. And importantly, the policy should be communicated to employees, and ideally, employees should sign off on an acknowledgement stating they understand their obligations under the policies. And finally, the company or the employer really should be consistently enforcing these policies. Another thing I would suggest is that employers should assume that this can happen. So with everyone carrying smartphones, using virtual meeting platforms, it's almost inevitable that conversations may be recorded. So I always inform my clients, if you're having sensitive conversations, you want to approach them cautiously and professionally. In more serious meetings, have a witness, have a note taker, prepare your speaking points perhaps and stick to those speaking points. As well, if you are concerned that employees might be recording a meeting, set the tone at the start and say something like, "This meeting isn't meant to be recorded. Please confirm you don't have any recording devices with you." This is a very professional way of just setting expectations. And if the employee lies and says they are not recording and then ultimately does, that could strengthen your argument around just cause, because not only did they breach a policy assuming you have one, but then they were insubordinate and they also lied to you, which would all be aggravating factors that would support an argument for cause. And lastly, if you discover that a recording was taken, take a measured approach. Don't just jump straight to termination or discipline in the unionized context. Investigate the context first and ask whether the conduct itself amounts to a breach of trust prior to perhaps taking the more serious steps. So with that in mind, what I'll do is I will turn the mic over to Victoria Merritt to discuss the next topic. Thank you, everyone.
Thanks so much, Roxana. So I'm talking about employee monitoring nightmares. This is a topic that has some overlap with what Roxana was just saying. I'm obviously going to speak about it from the perspective of employers monitoring employees, not employees monitoring their employers. But those risks, Roxana just flagged, if everyone has a cell phone and likes to record things, those are all kind of applicable in this space as well. Employee monitoring is an interesting topic because it's not actually that new. So, when I started my first job, I was selling diamond rings in a gift shop in Yellowknife, and there was CCTV footage that would have been monitoring me when I was accessing the locked case. So there's legitimate reasons for employers to be monitoring what their employees are doing, and those have been in place for a long time. And those are, health, safety, security of people, of property. And that again is not something particularly new. I think where the nightmare piece comes in, and where some of the risk comes in, is new tools really that emerged prominently during the pandemic around monitoring for kind of performance reasons, and monitoring what your employees are doing in a much more technologically advanced way, which increases the risks in this area. So when we're talking about monitoring, that's CCTV footage, recording phone calls, key logging and mouse tracking, GPS. The other pieces, which I'm not going to delve into in much detail, we obviously only have time to do a high-level overview of this very involved topic, are AI and biometrics. Those issues have a whole nother layer of risk. So we work closely with our privacy and data security team that Kirsten Thompson heads. And so if you are doing something that involves the use of AI or the use of, gathering biometric data, really get specific advice on that. And that has a whole nother layer of regulation and then also risk. So if we can go to the next slide. Is employee monitoring permitted? It's the spookiest answer of all. It depends. But legitimately, whether employee monitoring is going to be something that's considered offside or not by, for example, a privacy commissioner, is going to depend. So the key issue with employee monitoring is, of course, you are collecting employee personal information. So it's relevant what privacy legislation applies. We're talking to a national audience and some folks from outside of Canada. There is different privacy legislation that will apply, including, private versus public sector. And then, of course, what matters is what personal information are you collecting, how are you collecting it, and why. And I think one of the key takeaways here is that you should be prepared to justify your employee monitoring if it's challenged. And that means having an explanation about why it was necessary, what steps did you take to assess the privacy impact, were less privacy invasive options considered, and if they were, why weren't those suitable? And is the monitoring effective in achieving its objective? And we'll talk about these factors more. But really the key issue is, would a reasonable person find that the collection, use, and disclosure of the personal information was for appropriate purposes in the circumstances? And so while there's variations between jurisdictions, some of the core privacy principles are quite consistent. And I would also just flag, this is an extra sensitive issue in a unionized context. Again, of scope, we don't have time to dig into that, but arbitrators are also going to be looking at some of the factors we discuss if there's issues, and making sure the monitoring is minimal and is for legitimate management purposes. So next slide, please. So some factors to consider. The asterisk on this slide is, again, how these factors are articulated by different decision makers. Varies a little bit jurisdiction to jurisdiction, but again, these kind of remain consistent in terms of the sorts of issues that are going to be looked at. The first one is, of course, the sensitivity of personal information. This is why things like biometrics has heightened risk, because it's much more sensitive information to be collecting. Something like, what an employee is saying on a call in a sales context with a customer, and you're recording that for call quality monitoring and training purposes. We've all heard that recording. You get on a call, that's noticed to you and to the employee that this is being recorded. That's less sensitive. Reasons for monitoring, very important. And again, generally speaking, if it's health and safety related, that is going to be more acceptable than things like monitoring for performance or disciplinary purposes. Third, will the monitoring actually achieve its purpose? We'll talk more about this in a bit. Fourth on this slide is these less privacy intrusive measures. So the idea is that you should not be going to maximum monitoring or to monitoring at all if there's another way that you can achieve the same purpose without doing so. And then even within that scale of monitoring, it should be the least possible monitoring necessary to achieve the purpose. Of course, there's this overarching balancing that's done in some jurisdictions around whether the loss of privacy is proportional to the benefits. Again, if you're talking about privacy commissioners, they are going to be focused on employee rights a little bit more than organizations need to use the data. Typically, privacy is becoming more and more enshrined and more important. And then the manner of collection. So this is the how. How are you collecting it? Is it overt or is it covert? Obviously, covert monitoring is more problematic. Continuous or specific. Are you tracking absolutely everything your employees do on their computer all day, even on lunch breaks? And if they're using it for personal reasons and that's allowed, that's a lot different than specifically recording a call with a customer. I have controlled versus unknown, which I'll talk about. You might not even know what your employee monitoring software is collecting. And then, of course, how much personal information is being collected. So if we can go to the next slide, we want to leave time for questions, but I'm going to go through some best practices when you're thinking about or putting in employee monitoring tools. And many of these, I think, are fairly common sense when you think about what factors are going to be looked at in terms of whether this is justifiable and permissible. So before you implement it, really consider whether you want to conduct a formal privacy impact assessment or whatever the local equivalent is even where not legally required. This goes back to Roxana's point, just because something's not legally required doesn't mean it's not a really good idea or a really good risk assessment and risk mitigation tool. Use privacy impact assessments and that guidance to look at all those questions we just discussed and determine, is this actually worth the risk and what risk are we taking on? Second, does the technology actually do what you think it does? You really need to ask questions and understand what work. There was a pretty scary research done at the University of Waterloo where they looked at employee monitoring apps and asked, how are these working? And there were a number of design flaws and unintended consequences to these monitoring tools. A few examples. So many have employee protection or privacy protection features, but they have to be manually enabled. So if you don't know how to do that, or that's not part of your kind of terms when you're putting these in place, you may be gathering more information than you think you are. Another one that monitored had an app button that employees could press that would stop the monitoring. And it paused kind of a visible timer, up in your screen here. But the app actually continued monitoring the activity in the background without the employee knowing. There was another one where there were lags between the user activity and when the monitoring software actually said the employee was working. Obviously, if this is like a productivity tool and then you're going to try and impose discipline, you have a real problem there. And then this one was the most distressing to me was they found that there was a software program where you could select a feature that assured compliance with the EU's general data protection regulations. But when you actually toggled that feature on, it didn't change anything at the code level in terms of how the app functioned. So really important to understand what the technology is doing. Similarly, if you should obviously be having contractual agreements with anyone providing these monitoring software. Those need to address privacy considerations, get specific advice, especially if there's data transfer, and again, especially if there's AI or biometrics involved. You should, of course, be updating your privacy policies as needed, including, if you're Ontario, most employers need to have an employee monitoring policy. Really, we strongly recommend that across the country. I see my slides being moved, I think, because we're running out of time. But I think the rest on that slide are quite self-explanatory. Although I did want to touch on before rolling out, sorry, can we go back, Kate? Thanks. It's really important that you're issuing notice before putting anything in place. That is a legal requirement. Even if it's, employee personal information, you still have to give notice and practically consider the communications and timing of rollout, because that is going to impact how employees receive this and kind of the likelihood of people making complaints about it. All right, next slide. So once you have this in use, you can be auditing the system and should be auditing the system regularly. Again, make sure it's collecting the personal information you think it should be in the way you think it should be. Make sure it's only being used for the reasons that it was put in place and for the reasons that employees were notified of. So employees are entitled to know what information is being collected, why and how it's going to be used, and then you're offside if you're using that for other reasons that are not addressed somewhere that employees know. And this is often becomes an issue on front lines where there's a manager, maybe they think they can use this for something. Be very careful. Retention and deletion, of course, important with personal information, and security measures. Again, important, especially if you don't have as much control over the employee monitoring tool you're using as maybe you might otherwise. And finally, is this actually achieving what you need it to do? So if we can go to the last slide here, I'm not going to spend a lot of time on risks because I think these will be familiar to many of you. This comes up in lawsuits. Privacy complaints are obviously, I think, increasingly a risk for employers as employees become more and more aware of, and privacy is important, especially I think younger generations, not that old, but I think the next generations of workers coming up really value their privacy and transparency around this. And so do the privacy commissioners. And then there's other court claims, and of course it can influence the narrative as well in kind of more traditional dismissal scenarios, for example. There's some bad faith potential depending what's going on. And finally, I want to conclude by talking about what are kind of unintended consequences And this goes again back that just because something's legal or it's going to be defensible doesn't make it appropriate or a great thing to implement. And the US, I think, is probably the hotspot for employee monitoring. And the EU has very tight data protection and privacy restrictions. And there's been some studies coming out of the US that show employee monitoring kind of backfires. So a 2023 US study, which is called the Paradoxical Effect of Employee Monitoring on Deviance, great title, found that employees who were under surveillance actually took more unimproved breaks, intentionally worked slower, and I thought this was fascinating, stole more office equipment than unmonitored peers. Similarly, there was a study out of a human rights research center that found employee monitoring actually really impacts employee morale. It can cause anxiety, people will leave, and all of these harms disproportionately affect already vulnerable workers. So there's also a potential human rights component here that's maybe not explored and is even more risky if AI is involved, which we know has problems with bias. So really, I think, do that risk benefit analysis and be careful and don't get lulled by kind of the shiny new employee monitoring tool. There's lots out there. I know there's always articles about employers using them, but they are high risk and they also may not achieve what you want them to. So I will pass this back over to Scott to monitor our Q&A period.
Thank you, Victoria, and thank you to all the panelists. We've got a few minutes for Q&A. We've had several questions come up on the Q&A code or listings. I'm happy to try and direct a few of them. You're also welcome to kind of follow up with some of the speakers. We'd welcome that. One of the questions that was earlier on with respect to violence in the workplace was whether domestic violence requirements apply in British Columbia as well, or is this just an Ontario-specific thing? This is coming obviously from a BC resident. I wonder if one of you can answer that, probably Maggie.
Yes. So yes, there will be obligations on BC employers to also protect employees from domestic violence. On the slide where I put the definitions, you'll see that BC's definition for workplace violence explicitly contemplates violence by a non-worker. So while it may not explicitly state the term domestic violence, it clearly contemplates violence by non-employees, which can include an employee's spouse, intimate partner, family member, etc. And the guidance from Workplace BC or WorkSafe BC, excuse me, confirms that obligation as well.
Thank you for that, Maggie. We've got time for one or two more before I close. Can employers, this is probably a question for Roxana, can employers have policies that do not allow employees to make recordings in the workplace? So the opposite of what we talked about. Can they have such policies?
Sorry. So yeah. The question is, can employers have policies in place prohibiting secret recordings? And I would say,
Correct.
okay, absolutely. And that is actually something that I would recommend because it definitely comes up into the cases that we discussed, as well as if an employer wants to impose discipline. Because you know how I kind of look at policies is they set out the rules that employees need to follow in the workplace. And if you have a policy that's really well communicated, that's prohibiting such conduct, employees are aware of it, and they still breach it, then again, that's just lays the framework for potential discipline. And whether that's a written warning, whether that's something more serious, all the way up to cause, will depend again on context. But you definitely do want a policy, and you want to be able to rely on a policy, because absent that, it could potentially be detrimental, like we saw in the Rooney case, where the courts used that as one of the factors to say there was no cause.
Thank you. As sort of a follow-up on the Rooney case, another question in the chat line or Q&A is, even if the employer had a policy, isn't it reasonable that an employee who's feeling threatened in the workplace might feel it necessary to record the disciplinary meetings? Is there some contextual issues there that you could address?
Yeah, no, absolutely. And I think that would go to weight again, because I think in Rooney, I think one of the main things there that also influenced the decision was the policy, but there was clear evidence that the employer wasn't necessarily behaving the greatest. And I think that definitely weighed in favor of the court, like in favor of the court in terms of coming to its conclusion. So I do think like all those like a policy isn't going to be a full defense. Absolutely. There's definitely other factors that the courts will consider, and that will be one of them. So, you know, another case I can kind of think of off the top of my head, not dealing with recordings, but there was a case where an employee was being sexually harassed and the employer wasn't taking it serious. So they actually recorded the manager saying inappropriate things and even touching her inappropriately. So like if there's a context like that, and if there's a policy, I still think they're going to allow that in terms of potentially that'll come into play. And I know that's an extreme example, but have the policies, it provides you with protection. Will it be an absolute defense that you have it? No, I think you need to look at all the context, and that's really McKinley, the Supreme Court of Canada decisions, and all those other decisions. You need to look at the full picture.
Great, thank you. I think I've got one last one. It's not really a question, it's just some information for Victoria. Could you repeat the name of the US source for the paradoxical effect of employee monitoring?
Yes, so it's stripped of agency, the paradoxical effect of employee monitoring on deviance. And I'll flag that it's an academic study, so it's really based on like social cognitive theory. But if you're interested, that's the title, and you can access it.
Thank you, Victoria. In the interest of time, I'm going to bring this to a close. A couple of closing remarks from me. First of all, thank you to the panelists on this scary day. And I don't practice in this particular area full time, and I'm nervous now. So paradoxically, to use that word again, with all these threats to privacy, ironically, I think we have less privacy than we've ever had. So privacy laws are important, but they're being eroded. So that scares me. If you have any questions or need any tailored advice on this or anything else, please reach out to us. Any of these people on the panel or the firm generally, of course. We really appreciate your time and look forward to seeing you again in the next session. Happy Halloween, and I will say go Jays, go Blue Jays, go. I will say that. Thank you so much for your time today.